Government Operations and Fiscal Policy Committee, and this morning we have on our agenda one item. It's a work session on Bill 32-21, Personnel Employee Settlements Agreements with no rehire clause prohibited. I want to thank Council staff for their hard work on this particular bill. Also thank Council President Hucker for introducing this bill. And there is no doubt that there is a lot of alignment between this bill and our racial equity and social justice goals. I want to say that we did have a public hearing in July, and then just generally speaking, the bill would prohibit county employee settlement agreements to include a no rehire clause, provides the chief administrative officer or agency head the authority to include a certain clause, establish a right to appeal, and generally amend the county law governing personnel and human resources. A no rehire clause prohibits an employee from seeking future employment opportunities with the county, potentially removing years of experience and technical expertise permanently from county government. And there are some exceptions in the bill. One is the county and the employee mutually agree, or if the employee by the chief administrative if the employee by the chief administrative officer or agency head was terminated for cause. OCA does have some additional amendments that we will discuss. But before I turn it over perhaps to Council President Hucker, since he's the lead sponsor, I want to also acknowledge that Mr. Berchiatila is here from the Office of Human Resources, as well as that he can answer many questions related to this particular proposal. Council President Hucker, if you have any opening remarks, and perhaps then we can turn to Ms. McCartney-Green to go over the rest of the bill, and then we'll open it up for discussion.
I don't have much to add, Madam Chair. Congratulations. I'm happy for all Marylanders with yesterday's news. But yeah, the bill is pretty straightforward. I did want to add, since it's been a while since the hearing, that I introduced this at the request of the NAACP. It's a top priority for them. A no rehire clause, thank you for mentioning that. I believe eliminating it would be consistent with our racial equity policy. I just also think it's a good government thing. It's essentially a no rehire clause, is essentially sort of a employment death penalty for our county workers. And I can't really understand why we wouldn't want, as employers, the flexibility to have the greatest number of options available to department heads in the future, and to bring people back if the department head and the county executive in the future saw fit. So I think it only adds to our options, doesn't take away by doing that, and that we believe in second chances. We passed the state level, we banned the death penalty. At the county level, we banned the box from private sector employment. I think this is just consistent with, as employers, giving us more options and preventing any sort of personal vendettas or management, employee manager conflicts from getting in the way of somebody's ability to contribute to the county government in the future. So thank you for the opportunity.
Thank you so much, Council President. And also for my colleagues, you can just, wave at me if you want to make comments, etc. All right, let's have Ms. McCartney-Green go over the portions of this bill and the amendments. And then Ms. Green, what I would like is that, whenever there are particular decision points, if you can then pause and we'll have a conversation about that and take a vote.
Thank you, Chair Navarro, and good morning to council members, and thank Mr. Berchiatila for being here today from the Office of Human Resources. And so my packet that I have today that I will be going through, it's dated October 13, and it should say revised. I want to make sure that's clear and that everyone has the most updated packet that they're looking at today. And so, as you mentioned, we had a public hearing, and we didn't have any opposition to the bill, but we had two testimonies, one from Darrell Gorman from the Office of Human Resources, and from Ms. Cherry Branson, who is the chapter of Montgomery branch of NAACP. Along with that, we also had the Office of County Attorney review the bill and provided some suggestions. I decided that I'm going to start the memo, and I'm on page 2, looking at some of the issues that the Office of the County Attorney suggested and looking for discussion. So right now I'm looking at 1A. And so, like I mentioned, there's no legal issues with the bill, but one of the terminologies that we want to clarify in the bill is the difference between dismissal versus termination. And so under our Montgomery County personal regulation, termination is a non-disciplinary action, and dismissal, on the other hand, is an adverse personal action taken by a supervisor against an employee. And so with this bill, the term right now has the word terminated for cause. And want to make sure that we clarify that termination could be not for cause. And under section 29.1, which is circle 16, lists out a few enumerated reasons of why someone can be terminated. They could be on probation, failure to maintain a proper license, absent without leave. They could be a termed employee as well. And so that's not the direction that we want to have. And I know in other places, termination and dismissal are interchangeable. But under Montgomery County, I want to make sure it's clear that we're using dismissal under MCPR section 33. And so with that, I am recommending, and the council staff agrees with OCA, that we should amend lines 17 through 19. I'm on page 3 now. Looking at amending lines 17 through 19 and removing the term terminate the employment and replacing it with dismiss the employee for cause. And as I mentioned, dismissal is based on misconduct, which could include fraud, insubordination, embezzlement, harassment. And there's a kind of a laundry list, but not an exhaustive list under MCPR 33. So I want the decision point here is, should the committee adopt the amendment to remain consistent with the Montgomery County regulation and use the term dismiss rather than the term termination for cause?
Okay, any discussion regarding this particular recommendation? Good, President Hucker, yep, okay, we definitely want to align, so it's a 3-0 favor.
Okay, awesome, so then I will move along to my B, and this is also very complimentary as well. So the bill does provide some exclusion from when an employee, from when an agency head or a CAO can include the no rehire clause. But it also should align with MCPR section 33.8. And that says if an employee voluntarily resigns after the department director initiates a formal disciplinary action against the employee, the department director may include on the employee's separation papers that A, disciplinary action is pending against the employee, and B, the employee is not eligible for rehire. So obviously this is a case where there's some type of misconduct that may have happened, disciplinary action or proceeding has started, and the employee has said, you know, I'm out, I don't want to do this. So in that case, the county will be including that not eligible for rehire clause. So in the bill currently, that's not there. And so council staff agrees with OCA as a discussion point, but also as a consistency point to make sure that's actually pointed out. If it's in our regulations, I think it should be clearly laid out in the law as well. So amending lines 15 through 16 to include number 2 that says the employee voluntarily resigns after a formal disciplinary action has initiated by an agency head, a no rehire clause would be allowed in those circumstances. Decision point is whether to adopt that amendment and to once again align it with the regulations.
I see some nodding, so without objection, we agree with that recommendation. Okay,
great. And so I'm moving on to my 1C. I'm on page 4. And so this is more focused on this, whether to narrow the scope of the bill. So right now, employment disputes include any grievance, claim, or lawsuit filed against the county, which is very broad. And so the question is, if it's that broad, you know, what type of disputes would fall under this, and whether or not MSPB would have the purview to review that. So council staff took a look back and just reviewed it and realized that narrowing the scope to where, and I'm looking at 1C, amending lines 5 through 6, where it says employment dispute means any grievance, claim, or lawsuit filed by the employee against the county where a dismissal action is challenged. And so that narrows it to the certain misconduct where an employee may say, you know, I don't believe this is correct, or I don't believe that this was, handled appropriately, whatever that may be, instead of having a broader perspective where it could include other disputes. And one of the things that we talked about with the Office of County Attorneys, like a tax refund dispute or something else that's maybe non-employment related. And so that was taken into consideration, and the amendment there. And so the decision point for the committee is whether to narrow the scope of employment dispute, the definition, that solely challenges a dismissal action.
Okay, any comments from my colleagues regarding this particular one? Okay, so without objection.
Can I just ask,
yes, President Hunter.
Madam Chair, Ms.
Yes.
McCartney-Green, so can you clarify what constitutes a challenge of a dismissal? Would that include grievances, lawsuits, or other claims?
Yes, that are related to that dismissal action, yes. So that terminology is still there, any grievance claim or lawsuits related to the dismissal.
Yeah, I know. I mean, the committee can do whatever it wants, obviously, but I know the NAACP is not in favor of this amendment, at least because they, intentionally suggested the breadth that's in the current language and didn't favor limiting it in this way. But just wanted to pass that on.
Since you've been in touch with the NAACP, Council President Hucker, can you elaborate a little bit more as to why there is a preference to keep it broad? So for just practical purposes and explaining, because to be honest, I was trying to figure out the pros and cons of both what is in the bill currently and then why it should be narrowed. And so if I could hear a little bit more about your conversations with the NAACP and also some practical purposes, and Ms. McCartney-Green, also why do you believe that this would be either appropriate or, pros and cons as well. I don't think that you, you didn't make a recommendation on this one, right, Ms. McCartney-Green?
Right, and so I'm happy to kind of divulge into that.
Yeah, well, let me have Council President Hucker first expand a little bit about on his conversations with. Yeah.
Sorry, I don't have that many scenarios to add. The information I have from them was secondhand through my staff and their conversations with former Councilmember Branson. I think it was just that they thought it would this language would minimize the number of potential employees that would be affected by the law in the future. So I'm not sure I can add a lot of elaboration of particular scenarios.
One of the things that I was wondering was this notion of how this could constitute an additional barrier, especially for employees that may not even be aware of, particular avenues to do appeals and things of that nature. And is that something that we feel, it's not a barrier? Is it something, and maybe Mr. Attila can also chime in after Ms. McCartney-Green talks, that is something that I had, try to figure out whether if the goal here is to address something that definitely has become, in our opinion, a barrier to retain expertise. And I go back to this disproportionality conversations. I assume that's why the NAACP got involved in this. Would this then, maintain a certain level of barriers versus removing them writ large? So if I could hear a little bit from you, Ms. McCartney-Green, and then maybe Mr. Attila as well.
I know Mr. Attila probably has a lot more practical examples or, that'll be applicable. But I'm looking at it from a point of if there is a grievance claim or lawsuit, and it is a dispute, what falls under MSPB board, right? What are they able to look at? And, they're looking at dismissal actions, any misconduct. And so if it's a broad complaint, it kind of hampers a little bit what they're able to do on their end and what's within their purview. And so while I might understand that they are it's narrowing the claim. It's intentional to be able to allow the next process in that claim, lawsuit, or grievance. That's something that falls under their purview. And so we mentioned one of the things that came up was just discrimination, right? Are they allowed to look at that? And the answer is no, right? And so so that was the reasoning behind it, to limit it to misconduct that they were able to review under their current purview. And like I said, I'm sure Mr. Attila has specific examples, but another thing that came up was maybe an employee has a tax refund dispute, right? And they're not happy with it and they want to file it. So, not thinking of all the examples, but thinking of a few certain ones that may be an issue moving forward. And so that was the reasoning behind it.
I don't have any specific examples that I can speak of today, but if there is there's an interest to get it, I could definitely dig up some specifics that have happened in the past to provide examples to the committee rather quickly. But I think there's one thing that we need to understand is just like it's more on the educational side of the settlement agreement, because it's an agreement that is signed by the two parties, and then the problem becomes maybe the employee is not aware or doesn't understand that there's this no rehire clause. So that the acknowledgement and an education on the agreement, because at that party, it really takes it away from the individual to go against the claim, because it's an agreement, settlement agreement that both parties have signed. And it is assumed that both parties understand the facts, the footnotes, the little details about that. So when we discussed with Ms. McCartney-Green, and then we said just like there may be a grace period for it to just, I'm attacking the root cause now to make sure that when it's applicable, if we decide that that's that educational component that the employee should consider having, that employer should consider that having the employee completely acknowledge at the time that he or she or whoever understand that this agreement decided that the employee is not eligible for rehire. So that is the most I think proactive way to stopping any kind of grievances or dispute after the settlement agreements signed by the two parties, rather than trying to limit what can be. I would say just like moving up at the agreement point, just like making sure that we're cutting the ability to become these grievances after the agreement is signed, if that makes sense, my proposal.
Somewhat. Yeah, so President Hucker.
I did, coming back to me, looking at my notes, I know they had much more concern about Amendment D than this one. And I think they can live with this one if one outstanding question was just how an employee challenges a dismissal action, and if there's any benefit in maybe clarifying that in the language.
Okay, right. So that's why I was a little confused, because I when I read the notes, etc., I thought that it was D, and then when you made those comments, then I thought, hold on, are they like related? So thank you for clarifying that, Council Member Feetson, and then Councilmember Katz.
Yeah, appreciate that. I mean, I think obviously the whole point of this is to make sure that employees' rights are not violated, that there isn't a power dynamic where the county leverages the power of the government over a person who is in a much lower power dynamic.
Right.
And yeah, that's the whole purpose. We all appreciate it, and that's why we want to move this forward. I think the question is, the whole point of a settlement is to avoid the drawn out litigation and processes for both parties, at least in a world where it works. And so that what I haven't been convinced of on either side, frankly, is which one of those is more compelling here. And yes, I find myself in the position that Chair Navarro you mentioned of I understand where both sides are raising here. It hasn't been compelling with any particular examples of why limiting this would be an example would be a problem, but we haven't really heard a compelling reason why if you didn't do it, it would be a huge problem either.
Councilor Katz.
Thank you very much, Madam Chair. I actually am confused. I think we're starting to straighten it out a little bit. But if somebody sues the county because a county employee is struck by a vehicle owned by the county, and ultimately that I hope that it never happens, but if that goes to court, then that person in the settlement has nothing to do with their employment. I mean, they were driving their personal car. That person in the settlement would be subject to that they would be they couldn't be, that they would not be able to be employed by the county and not be able to be rehired. To me, that's not fair in the slightest. So I think I don't know whether what we are saying here actually does what we are talking about, if the amended lines actually does it. But this should strictly be about employment. It should not be about any other dispute, as far as I'm concerned, other than the employment. And we amended this to say that for 15 and 16 that it has to be for a formal disciplinary action, and this should be just a continuation of that. If this has nothing to do with their formal disciplinary action, then they should be able to be rehired.
Ms. McCartney-Green, can you please clarify then? Because I guess I'm not the only one that's confused.
Yeah, and I see us merging kind of the 1C and the 1D that's talking about, their rights after. So I want to make sure that we separate those two things, and I definitely can go back to that. But so the first thing is working on employment dispute, right? And whether that is broad at this point. I've heard comments from Councilmember Katz that mentioned that it should only be employment related. And so the issue is that if it's employment related, what type of matters does that include? And so right now the amendment is, should it just be dismissal actions for misconduct? In your case of the individual driving the truck, if it was a county employee driving a county vehicle and they were driving negligently, right? And hit someone and came back and agency had said, listen, this was a violation of our policy. You have been found to be in misconduct. They would have a right to challenge that under this narrow clause. So that's what I am suggesting. In terms of keeping it broad, it just falls under anything, and it's just harder to narrow that. Like I said, the concern is not just a grievance or a lawsuit that's filed, is what happens after. What is the employee allowed to do, and what does MSPB have jurisdiction to do? And so the county code actually enumerates some of the things that MSPB is allowed to do. So that's the direction that I'm going, is that to limit it to conduct that is related to some type of dismissal action and has to be employment related. If that's misunderstood, then I'm happy to look at other ways of defining it or other ways of making it clear to make sure that it's not misunderstood on both from the county's end and from an employee who's trying to use that proactively.
Councilmember Friedson.
Thanks for that clarification. I think it makes more sense after you clarified it. And I did go back and reread, and it's filed by the employee against the county where a dismissal action is challenged. And I think that's the aspect that you're trying to narrow it to areas that MSPB would have jurisdiction over. So unless there is a significant objection by the sponsor on this one, I would be comfortable going with the county attorney and staff recommendation.
Councilor Katz, how do you?
I'm fine with the spirit of it. I just don't think it's clear what we're saying. If we could reword it to say what Councilmember Friedson just said and others, then I'd be fine with that. But I just think it's confusing the way it's written.
Thank you. So what we'll do, Ms. McCartney-Green, is that if you could please work on some modified language and then share it via our chiefs of staff. I hope that you have enough, sense of what the committee would like to do, but we just want it to be a little clearer. I would agree with that. And then when it comes to full council, of course, we'll be able to present it.
I can do that, Chair.
Thank you. Okay, the next item.
And so the next item focuses on, if the agency has chose to include the no rehire clause, what's available. And so the issue is, right now, and I'm looking at 1D, whether a right to appeal to the Merit System Protection Board is the best remedy for an employee to challenge a no rehire clause in a settlement agreement. And so OCA presented a few policy and legal considerations for the committee. And really, and I'm not going to read line from line, I'm just going to go ahead and speak off the cuff because I have a good understanding of it, is the point of a settlement is to avoid litigation. And so the issue is that if an employee challenges this no rehire clause that's included in the agreement, the issue is who has the burden of proof to say that it shouldn't be in there, or has to be able to show what standard of review should that be. And so it started to complicate the layers of the rights of that appeal. And so looking at that, it opened up more can of worms than less. And I know the intent is to provide, as been said here, the employee some right to be able to challenge that and not have like a adhesion contract where they have no terms or anything that they can include. And so with this case, if there is a settlement that has been agreed to the terms, and the last thing that's outstanding is the employee says, I don't want to have this no rehire clause in there, and it's in there. Well, that pauses all negotiations, right? That pauses the settlement right there. And then they would have to go to MSPB to decide, should this be included? Well, MSPB is going to want to hear, what are the merits of the case? Where's their wrongdoing? And not only what are the merits of the case, but the county, I guess, would have to prove more and above of why to include that clause. So it seems like it particularly hampered the process than providing a prudent solution. And so what I did was I looked at other options. What can we do when there's a settlement on the table and there's clauses and terms in there? And I think some of the underlying issues here is that an employee might be signing a settlement agreement not knowing that the no rehire clause is in there. They may find that out later on and, may have been buried in there. And so I am looking at page 5 of my staff report, where making the recommendation for an amendment to amend lines 21 to 24, removing that right to appeal, and instead providing that a settlement agreement that includes a no rehire clause is permitted under subsection C is valid when the employee has knowingly and voluntarily acknowledged the clause in writing. 2, the employee is advised in writing to consult with an attorney prior to executing the agreement. And 3, the employee has at least 7 business days to consider the agreement. And so this goes to the essence of providing notice voluntarily and the opportunity to make an informed decision, possibly represented by an attorney. So this is addressing the clause up front rather than after the fact when the employee has signed it and has been banned because of that clause. This is a suggestion that I have made to the sponsor. I know there are other competing interests there, but this is just me looking at the process and realizing where the appeal process may not be, although legal, not be the most prudent solution in that scenario.
May I add something because we had a great conversation about this, and I do understand that it's like the standardized no rehire clause being added is not or should not be the standard practice. However, obviously, the reason why the no rehire clause is for the EEOC and in the protected class, we just do not want, like the private practice have, when there is a claim against a harassment in the workplace. Oftentimes, part of the settlement offers, the private companies do not want that individual, the victim in this case, to be prevented from coming. They get the settlement, but they don't get what they needed. So what we're trying to make sure is to protect those individuals that are not subject to that similar clauses in the Montgomery County government. But that doesn't mean that there are certain instances where the no rehire may be very applicable because depending on the dismissal and what the offense was, not necessarily maybe the offender of the sexual harassment or the workplace violence or somebody's embezzling. So in those cases, and the termination for somewhat any kind of settlement agreement, we would like to leave the avenue for the county, not in a standardized way, to be able to include the clause, but just not include the clause and bake it into the long term of a settlement agreement. But again, going back to the educational component of it, giving enough time to acknowledge and understand. Both times when it's that done, I do believe, and I think OCA agrees, that appeal comes that after one. County is going to be in a strong position that just like we have done X, Y, and Z, and then you have the time acknowledged and signed. So just like it really takes it away from the appeals process, and it gives us a strong hand no matter what they go and grieve. But by not putting it as a standardized, every settlement agreement will have a no rehire clause, by putting some factors around it is just going to be very needed, because we do not want our anybody from a harassment victim to be says that we severed our ties with you and you cannot come back to agreement with the county. So we do believe that could achieve good outcomes on both ends.
Okay, I'll open it up for discussion. The only thing I will say about this, and I think that's why for me it's I'm trying to figure out how this works. I'll be honest, there was an incident that happened on the council, and it was odd because it included me. There was an EEOC complaint that was filed on my behalf that I never requested, but then there was a conclusion, there was a finding, and nobody ever explained to me what that meant. And so it made me really think about and reflect on, okay, if this is happening to an elected official, I had no idea the resolution, what would happen, et cetera. I never signed anything. Imagine for employees who may not really understand this whole process, who may not, even realize, oh, okay, so now I have to find an attorney, et cetera. It just gave me pause for exactly how it is that we are conducting a lot of these processes. So I just wanted to share that. It's the first time I've shared this because it was just odd. And so now as I, think about some of these pieces and how the onus is on the employee, et cetera, I just want to make sure that we're baking in enough, information support, outreach, whatever it takes, so that employees are aware of where their rights are and what their options are, et cetera. I just wanted to mention that as just something that gave me pause as I was trying to figure this out in terms of this amendment. Let's see, Council President Hucker.
Thank you, Madam Chair. I'll just pass on. I wish Councilmember Branson could have been joining us. She had a commitment, and we just got the amendment yesterday. I know the NAACP feels like this amendment in particular, not the other ones, drastically changes the bill by limiting the scope of it and allowing many more no rehire clauses in other circumstances. I think Councilmember Friedson was right, spot on, his comments about the importance of the power differential for all of us to consider, that the county really holds all the cards in this negotiation. And the employee may feel like they need to agree to these terms because they really need the position. They may not be able to find an attorney in time. They may miss that detail of the requirement here and regret it later. I know from speaking with the advocates, they felt like this really significantly sort of guts the bill and allows many more no rehire clauses that employees may regret in the future and may rob the county as an employer of the ability to bring back people that could add value to public service and to our residents. So, I don't believe this one's a good idea, and I think keeping in mind the power differential is important here because that wasn't really covered in the packet. Thank you.
Councilmember Cutts.
Thank you, Madam Chair. I agree with the Council President. If you look at when this type of situation is going to happen, and an employee who maybe can't afford an attorney, I mean that's the first thing, and the fact that they could be rehired doesn't mean that they necessarily have to be rehired.
Yeah. Yeah.
That all this does is give an option that says, you're leaving. Thank you very much. If you want to apply for this or some other, and to Mr. Attila's thoughts, if it should be a part of the person's employment record that why they were all of this should be certainly known. But I believe that this is something that the employee who's really stressed out at this point, can't afford an attorney, is looking to, maybe doesn't have much money left to fight this thing. At some point, to Councilmember Friesen's point, throws up their hands and says, you know what, I can't fight this anymore. Even though it's not fair, I can't fight this anymore. I'm going to have to leave. And then couldn't be rehired afterwards. I just think that's not fair. I really do. So I do oppose this part of the suggested amendment. Thank you, Madam Chair.
Councilmember.
Yeah, so I have real concerns about narrowing it to the point where we do fall into the power dynamic. I think that's the whole purpose of the bill. I do understand the county attorney's point of a settlement and the whole reason for a settlement, and trying to figure out a way where you, as part of a negotiation, you're providing an option to go to the merits of the case, which is the point of a settlement, is to avoid that step where you actually litigate in an administrative or in a legal setting the merits of both sides of the case. So I don't know if there's another option here. I will say I'm not comfortable. I appreciate what was proposed. I think it does reflect what the county attorney was looking to do. I think that is too much in terms of what the goal of the intention of the bill is. If there is some other option that maintains the functions of a settlement and the rationale behind a settlement for both parties, but doesn't eliminate the rights of the employee who is being separated at that point, I would be open to entertaining it, but at this point I wouldn't be comfortable moving forward with this amendment.
Thank you, Councilmember Friedson. I'm thinking that because now we have language that we need to consider, and then plus this particular one, I think that we should come back to a very short, we can schedule this item in GO, very short discussion to address the language that I requested, Ms. McCartney-Green draft, and then as well see if this can be refined a little bit further. I associate myself again with all the comments that have been made. This is obviously finding a way to not add more barriers, but actually remove them. And so perhaps we can go ahead and just schedule another short session, maybe in another GO meeting. We can just attach this one sooner than later. I think that we've made quite a bit of progress, but do need to think through a lot of this. These particular additions. I mean, it seems like the members are interested in some different type of language. It's good to also remember that this is not part of the bill. These are amendments that were recommended, but I think there's a little bit of interest. There is interest in perhaps refining that a little bit more, see if we're comfortable, and then we can decide whether we want to incorporate them or not. But I obviously don't think that we can do this, without another short discussion regarding this. Okay, Ms. McCartney-Green, what are the other two areas? Okay, I don't know, third. Yeah.
The other ones were really easy and quick. And so the question is, if a court of law determines that a no rehire clause is found to be void or unenforceable or unconstitutional in any way, that a settlement agreement would still be enforced. And so nothing in this bill impairs the county's ability to include a severability clause where everything else in the agreement would still be in effect, and that's just standard and just more clarity there with that number 2. And then number 3 is just talking about the impact, both fiscal, economically, and the racial equity, social justice impact for the bill, and there are no material impacts there.
Fiscal, economic, and
that's the nature of that. It's a small amount of employees that this is affecting. This is not a large amount, and although it's not automatic to include a no rehire clause, it is a part of the standard that it may. And so this bill will now remove that standard where it's not going to be standard. It has to be under certain circumstances. I do understand the committee's back and forth of trying to figure out how not to limit the rights of an employee at the same time of figuring out a process that works. So I have taken that into consideration, and we'll go back and look at how to broaden that appeal power.
Just one of the advantages of like applying an Ohio reclose on an agreed upon circumstances would be like a large organization like this is just a generalistic control of an employee that we really do not want to be employed with the county anymore for a given reason, right? Let's agree that there may be reasons out there that we just do not want this individual to come back because they have just done something that it's not acceptable. If they do apply to another job, the supervisors and everybody else may not know that there's a no rehire clause for this one. So this allows us to be able to come back and immediately terminate or stop in its track. So it gives us, the county as a whole, some protection. It's just, it should be a protection, not an enforcement or abuse. So this bill is written, I think it's just going to get us to more where it's needed position.
Councilman Richardson.
During the hiring process, is HR able to access past employees' HR records?
We can, if it's prompted. It's not standard. We have the background policy check, but the settlement agreements are obviously confidential, and they're not going to be able to access that. And specifically, the HR liaisons at the departments will not know unless it's specified. If an individual that is dismissed or agreed come back in 2 months and applies for a job, the county will not have an automatic way of knowing if this person had a settlement agreement with a no rehire clause.
I think it's separate from this conversation, perhaps related, but if a former employee is applying for a job, if they have stellar marks from their prior employment or they have horrible performance reviews from their prior employment, I would think that would be extremely relevant information. I would also think that, in order to hire somebody and pay them with public dollars and have them taking on, public responsibilities that are, some of the most important roles in the county, that we're checking references, including those with the county government. So I would hope we have a system that is able to weed that out as a standard course of practice. I mean, I think that in this case, we're actually dealing with a very small group of employees for a very large organization. But if we don't have a system that is better equipped to understand both positively and negatively the past employment behavior, conduct of employees. I mean, I sure, all of us have hired people in county government. I've run, public agencies before. Certainly when you hire somebody, if they have worked within county government, it's pretty standard practice that the manager or the committee that's responsible, is making a phone call to the references or looking at the resume and seeing where they've worked before and finding out, what kind of employee were they? How did they do their work? How did they go about their work? Did they take on more responsibility? And so I would hope that both in an informal way and also in a formal way, that we have a way of going through references, doing the type of checks that we should be doing to make sure that the folks that are working for county government are the type of people and employees that we want and expect. And I would hope that we would make sure that is happening.
So
I just want to interject quickly because we do have a GEO public safety session and we're running a little late. It seems like this is, definitely something we should have a conversation about, because it is connected to this bill. But I just wanted to, be respectful of everybody's time and the schedule. And so I think what we'll do is that we'll wrap up this session. We're going to come back to it ASAP. Ms. McCartney Green, I think that you have enough information about what it is. It's a very, I think, surgical in nature, what we would want to see, and then we can come back, do a, have a quick conversation and go. Council President Hucker, before we wrap up.
Thank you so much for considering the bill. I just wanted to quickly follow up on Mr. Attila's statement, because I was going to ask the same question as Councilmember Friedson. When would a director ever feel compelled to rehire somebody, that they didn't really want to hire? And your answer is basically they might do it sort of by accident without having the virtue of that information of their previous performance. So it sounds like there might be a long answer here, but I totally agree with Councilmember Friedson and probably everyone here. If I'm a director, I would think I would want all our directors to have lots of information about the prior performance of every employee. And I'm interested, maybe you could provide us in writing what types of information I have access to and what types of information might be shielded, through their employee protections. But I'm curious about that myself, because I would want our directors to have, all the information that they need to make sure that we're hiring the right people and jobs.
Yeah, undoubtedly. Yeah, and maybe we can, Mr. Attila, and I'm sorry to just allow you, because I want to switch over to the next, but perhaps then we can have a conversation about that as well when we come back on this bill, because as I said, it's connected, and it seems like it's a very important point.
Absolutely.
Just for us to have. I thank you. Okay, with that, we're gonna switch and go into the public safety GO. So thank you, very much, Ms. McCartney Green and Mr. Attila. And
thank you so much for having me.
The conversation. Absolutely. Thank you so much.
Thank you.